Freund, who will give us a bit of a non-EU member perspective on some of the aspects that are important here. Well, I think the first case we wanted to touch upon is how Germany actually tries to push the boundaries of where its rights of taxation end. And you all have heard a bit about it recently, but I would still want to go into it and give you a quick update on where we stand as opposed to last year's presentation on this matter, because there have been a couple of developments, some very fortunate, some not so fortunate, that you may want to listen to. Essentially, if we switch to the next slide already, the domestic rules in Germany are very, very old tax rules that have not been changed materially since being introduced in 1925. So almost a century ago, when we didn't have OECD principles, but only the League of Nations, we've tried to find some grasp to Nexus. And the only grasp Germany had was to say, if there's anything registered in Germany, then probably this may give rise to some sort of German right of taxation. That's been in our laws ever since. Nobody really cared about it until about 2 years ago or a year and a half ago, the big four companies started bringing this up with each and every of their audit clients and saying, well, we've read the law and I think it applies here and you need to pay taxes. Well, ever since, there's been a huge debate going on. Obviously, industrial associations have been pushing the revenue to give some leeway to the corporates, because obviously in any transaction that happens globally for an IP portfolio, there's a high likelihood that some of it will also be registered amongst many other jurisdictions in Germany. And the mere compliance burden this creates is extreme if you look at it, and in many cases may have very, very, very little help. In essence, Germany would say, well, if IP is licensed to a German tax resident licensee, obviously, yes, we do apply a withholding tax, at least where no treaty reduction to zero is applied for. And where there's a German tax resident licensor, obviously, if he receives the royalties, then these are subject to German tax. But if it's registered in a German register, and that would be the German patent register, the German trademark register, the European Patent Office registration would also qualify. And we're discussing to what extent the European trademark would also catch a German taxation right as well. I think the news development we had is that in February we received a bit of a circular saying that the registration solely in Alicante should not give rise to a German right of taxation, which, given that Alicante is not in Germany, is well, reasonable outcome of that discussion, and I think we shouldn't have had it in the first place. But since it was already claimed, this should also qualify. There's at least the minimum leeway that we could have gotten has been obtained. As I said, this is in breach with a long-standing interpretation of the law, because ever since we were in OECD treaty jurisdictions, never ever has it been challenged that a third country transaction between, say, two US corporates over an IP portfolio, which entails a couple of German trademarks, should fall under any German right of taxation. We would always have said, well, none of them is resident in Germany, none of them has a PE in Germany, none of them should actually be bothered with German tax compliance rules. But this has changed, and we've had the developments happening ever since. We had a legislative proposal in January, which would have taken the issue off the table again by taking the legislation back to the interpretation that has been standing for almost a century now, and only taxing this if there were another German nexus, such as a German licensor or a German licensee, or IP rights that are held through a German PE. Unfortunately, given that this is a year where we have a general election coming up, the parliamentary proposal failed to go through Parliament, as any significant improvements to corporates tend to do in such years. And therefore, we were then stuck with the ministry issuing a fig leaf, I would say, circular letter that provides for a teeny weeny tiny little bit of leeway to larger corporates. So in a mere treaty case where you can clearly prove treaty protection, you are not forced by the revenue to declare your past transactions for the last, and the last open years would be all years from 2013 until now. You needn't declare these. You only need to apply for an exemption certificate. And if you get that for this transaction, then you're fine. And that should also be issued retroactively, which is against the law, but which would be some sort of administrative help, given that the alternative would be to collect money first from a non-resident and then refund it to a non-resident. Makes quite a lot of sense because this is almost impossible to pursue. Unfortunately, Germany has not gone much further than this, and a recent chat we've had with a couple of colleagues from the Big Four companies sort of gave us a look at the current caseload they have. Ours is almost as large as theirs, although we don't have as much compliance work to do with it, but already more of a preparatory work towards some sort of litigation or dispute. I think every Big Four company has at least 100 clients that they are still working on this with. And every one of these has roughly around 500 different royalty transactions that are subject to reporting requirements under these rules. The reporting deadline for taking advantage of the circular letter I just quoted is September this year. So you can imagine that there are myriads of associates at any Big Four company currently compiling information that in the end will not lead to a single extra revenue euro in the German coffers. It will lead to some extra revenue for all Big Four companies, and I might say it may also have something to do with our profitability this season. But it is obviously more something that creates a lot of work, but nothing that creates a lot of revenue. If we move to the next slide, you will see that for treaty countries where this applies, and the treaty network is everything that's either orange or red in this map, you have the vast majority of jurisdictions that are important that are covered by treaties. So unless you have indeed got offshore IP or an onshore transaction that fall outright under the rules we've just discussed, any royalty streams and transactions would fall under treaty protected territory and therefore not give rise to any extra revenue, but to, as I said, massive amounts of compliance work. We do see that the Federal Tax Office, which has a department of, if I'm not mistaken, about 15 people dealing with all these cases, is currently being swamped. And we have not been able to obtain a single exemption certificate yet because they are all testing the cases very thoroughly. And they have so many cases to test very thoroughly that this is taking forever and ever. We were lucky enough to get a forward-looking exemption certificate for 2 clients so far since filing about half a year ago, not the retroactive one that we also applied for at the same time. And we are always being asked to provide further information and further information and further information. So, for example, you do have to provide the registration of the licensor and the IP rights in the name of the licensor. in many transactions, economic ownership of IP rights and license ownership in registers will not be the same. And then to prove the chain of title to the economic owner who is claiming the treaty privileges is quite a cumbersome exercise and can take very, very long periods of time, particularly given that the German authorities aren't accepting all documentation in English, but require translations rather often, which adds to the timing and cost of all of this. All this in an area where, and if you look at what's not orange or red on this map, there is not very little, there's not a lot of important space left on the map where anything serious could come in terms of revenue. Well, where we are, though, say in the ocean, somewhere between the US and Ireland, if we move to the next slide, obviously there's more juice to the bone. This here is a photo that I suppose is the Bermudas. Obviously, where you have that, you don't have treaty protection, and Germany applies its taxing rights and just adds something that they would want. They will require full withholding, which again is very difficult to enforce against a non-German taxpayer. The main means and leverage Germany has tried exploiting so far is saying that since all large corporates should be informed of this, their managing directors might face criminal charges if they do not comply. It does give you a bit of a taste of how this is being treated. And it's not very positive for me, who's always been a firm believer that Germany is a relatively conservative and well-run state in many ways, but who finds that this is no longer as true as it may have been a couple of years ago. You don't have a refund procedure, so there's no relief that you can claim. Wherever you have these cases, you can't just apply for the exemption certificate, which already is quite a lot of paperwork, but you really need to file all back periods until 2013 to escape the potential criminal law consequences, and then even pay the tax, which obviously means, again, that this is a rather cumbersome exercise. In this case, however, I can see that the revenues point because there's at least money to be taken from this. We've had the onshoring transactions in the main session earlier, so I'm not going to go in too much detail here, but you can imagine that all these onshoring transactions, where they also dealt with German registered IP rights, do now give rise to all sorts of cases where we will ultimately end up litigating, mostly on transfer pricing grounds, because, as we mentioned earlier, it's very difficult to say that a German registration carries any significant value over a European registration as a trademark or a non-German patent right that still is protected under all sorts of treaties also in Germany. If we move to the next slide, I think I would want to take this as a quick interruption before we go to the second case that Hans will present, and take a bit of a look around the globe and then ask our distinguished panelists how they see this overall. I mean, what do foreign revenue authorities make of this approach? I think when I first saw it, I was flabbergasted that he could actually do this and not feel guilty about it. But that may also be my very own view of things. And if you, Phillipe or Hans, are able to add to this, what you would see, it would be very interesting.
Yeah, I mean, I'm not sure that there has been a huge amount of reaction by view of plans to introduce similar provisions in the UK, which is where I'm coming from. But in the end, I mean, as you said, there is a finite cake which has to be split up in a certain way. And I'm not just looking at the IP for one particular company. But I mean, if I look at a global IP, there's a finite cake of IP, and the taxing rights have to be split up in a certain way. Now, if Germany starts taking a piece of every of the cake, which in circumstances where there is no nexus, as we discussed, that piece of cake is potentially missing in another jurisdiction, and I could see that it's a bit like the when someone stands up in a cinema because he therefore has a better view of the screen, that works as long as he is the only one who stands up in the cinema. If everyone else stands up and he's in the starting position and potentially in a worse position. So I think that I mean, it will be interesting to see how tax authorities will react to that, because having tax withheld for Germany is potentially going to affect their own tax earnings. Now, I think that is one side of the matter, is really looking at how tax authorities are dealing with it. I think by far the more worrying aspect of that particular approach is the impact it has on taxpayers and on compliance in situations where you have a transaction which has absolutely nothing to do with Germany, and that I think impacts large corporates certainly, but I think it impacts to a greater extent small and medium-sized companies who have IP registrations abroad, including in Germany, because the exercise that is involved, or seems to be required in Germany, to be compliant in Germany, is actually a massive compliance burden. It is retrospective, so we are looking back, from what I understand, 8 years. 8 years in which a lot of things kind of happened with the company, with the licensee, with the licensor. So let's look at one situation. The obligation to withhold the tax is on the licensee. The right to reclaim is on the licensor. So there is not going to be an agreement in place between the licensee and the licensor for the licensor to repay those amounts. How can the licensee force the licensor to repay those amounts to him, which he is now obliged to pay over? That is, in my view, a massive problem for companies where cash flow is, I mean, either cash flow or the financial position is not brilliant. Even if you can get it back, there will be a delay in time before you do get it back, which will affect your cash flow. And I think that is a massive problem for a company. The next thing is, who can claim for the exemption? My understanding is that the exemption can be claimed for by the licensor, who has to show that he falls within the treaty protection. But there is no obligation on the licensor to do so. So that fig leaf that you mentioned earlier only applies insofar as the licensor is prepared to cooperate and to do all of this extra work that they have to do to make sure that they can say, well, we have in all those years fallen within the protection of the treaty, and can demonstrate that we are prepared to produce all those documents the German authorities are requiring. We're prepared to produce those documents in German in circumstances where the German language version doesn't exist. So the question is, what can be done if they say no? What happens if the licensor no longer exists? This is a historic thing. So we're looking back. The company, especially in this day and age, which was the licensor, may have gone bust. the obligation to pay the tax will still exist, I presume, in those circumstances, because there's a historic obligation to pay tax. It will result in an absolute charge, which is irrecoverable for the licensee. And I mean, I think I see lots and lots of issues with that law and the application of the law. There are other issues as well as to even in the future interpretation. How do you know that the IP may be registered in Germany? How do you say what the tax base is? How do you determine the tax base if you do not charge on a global sales basis, but on another basis? How do you determine what the tax base is? If you are then trying to reverse engineer it and look at how much what the global sales volume really is, where do you draw the line? Is the global sales volume at the licensee stage, at the sub-licensee stage, at the sub-licensee stage? I mean, we're getting into a huge amount of difficulty here, and that I can see may well be the trigger at which governments and their tax authorities might step up and say, well, listen, I mean, if you're doing that, we have to protect not only the revenue, but we have to do something to protect our companies from this kind of egregious behavior, and we will need to step in. That's my view. Is of course only, well, I think it's hope actually, because I think that for especially SMEs, this is really bad news.
You mentioned already many aspects. To my mind, some news facts from this week came along, like about Ryanair and Belarus. Yeah, sorry to say so, Gunnar, but if this negative effect of the German tax administration leads to disadvantageous treatment and money lost, I would say, as a Dutch tax lawyer, call Gunnar and let's see whether we can do something with European Court of Justice, since more and more European Court of Justice does apply as a source of law also the OECD Model Tax Convention, specifically when the treaty as such, the German-Dutch tax treaty, is a little bit different on certain aspects, but it's all about the relevant aspects, and that could be a way forward. Secondly, you said something like 8 years retroactive effect. Was it 8 years?
It is actually only 7. The 8th year comes from the fact that Germany claims if you didn't do it in 2020, where you would have known, then it would probably be tax evasion, and then you can go back 10 years. So we're keeping you stuck for another couple of years if you don't report now.
Okay. If it is so, and this is perhaps a little bit too much detail, if it's so that at a certain stage the Germans found out that they had these old laws they could apply, and they never did it before, it would lead to a retroactive effect of many years. Yeah, I'm currently working on a case where we try to apply the European Convention for Human Rights and of course the EU treaty, the human rights part of it to apply here, because if it's that's at a certain stage they go 7 years back in time and say, hey, by the way, we forgot to levy that part of taxation, it might also work, though the procedure with the European Court of Human Rights is not really interesting, but it's a long one and a difficult one, not as effective as for the European Court of Justice. But that would be just my primary remarks, Gunnar. Besides all the things Phillipe currently stated, which are really, in practice, very terrible, difficult discussions.
And for most of it actually, for the clients that actually came forward so far, it's just a huge compliance burden with no extra revenue, to be honest. So it really is a bit of a mess there. I've had another question on this to both of you, and there's, where does this lead us in terms of where is the future of Nexus going to? I mean, we see other areas of tax where it's sort of slowly crumbling away. You look at digital services tax or source state-based taxation that's increasingly being used and or at least claimed to be required. Would we go anywhere beyond IP rights to apply and slap this on? It is quite a difficult thing to look at. And do you have any thoughts on this?
In Pillar 1, the IP rights are part of Amount A. Now, let me just say they're not included in the discussion because it's accepted that companies can develop intellectual property rights which are being used in order to do global sales. In a way, you see the same thing on the alternative intel B. I'm not sure whether Nexus as such is going to change that much, because there's Nexus and Nexus. If it's all about intellectual property rights and the connection with where, then B. Perhaps you're right. Then B is a tool which can lead to the conclusion that your intellectual property rights might have more, let me call it, location, since the development and the enhancement takes place in country A, but protection takes place in country B. Country C does the maintenance, and the exploitation is taking place all over the globe. That could be a reason to say that, Nexus probably can be divided. But yeah, a good question, but not a very clear answer from my side, at least.
Okay. I think, Philip, if you have a quick one on that, we may have just about the time for that before we want to go into the news that Hans has already teased us on.
No, I think I agree with Hans. I mean, it's very difficult to see.
I'm not hearing you, Philip, but it can be my connection.
Sorry, can you hear me?
It's better now.
Okay, sorry. I think I completely agree with Hans. I mean, I don't think it's very clear where we're going to go from here. I think yes. I mean, that will be one way. I'm not sure. I mean, I think that the main problem we have with this is wherever we go, the retroactivity that is included in this proposal, or this approach, is really the killer. You think you can develop many things by consensus going forward, but I think it's the retroactivity of this and the retroactive need to comply, which makes it very, very difficult in practice for companies. But, yeah.
Great. I think with that, I'll just pass the floor to you and the new developments in the Netherlands have.
Thank you very much. Well, first of all, I mentioned in the previous part that the Netherlands did implement, worse than any country, I assume, the OECD BEPS plans, and accordingly also the directives of the European Union. But we have a tough political discussion going on for years now, and that has led to a report of a working group in the Netherlands, which looked into new possibilities to challenge tax avoidance. So apart from all the BEPS plans, we tried to challenge other forms of tax avoidance. And one of those issues challenged is a situation, two situations actually, this number 6A and 6B. 6A is about shifting IP from country A to country B, to the Netherlands. And 6B is selling it at fair market value to the Netherlands. And actually at this moment, only the first variant is in discussion. So the discussion, as I explained it before, in the last session. So 6B where you actually sell IP from Bermuda to the Netherlands is not yet planned for a reform, that means that if I'm in Bermuda, I have my intellectual property there, I just sell it to the Netherlands, taxation 0%. It's excluded from the consultation paper, so which means that possibly, although I don't expect it to be honest with you all, possibly this could still go fine, which means that onshoring the IP would lead to a depreciation on the fair market value. However, the point is that we do expect the second situation already soon to be covered also, mainly because there is a strong group of people in the Netherlands, tax lawyers, tax professors, working on making the Netherlands the country where no tax avoidance as such is possible. For me, I'm also, as you know, a professor at the university. The main thing is that onshoring as such is based on our case law since 57, 55 actually. And that case law also departs from the total profit situation. So you can only be taxed for profit you really make in your country. That's the example of Coca-Cola. If I would be allowed to sell Coca-Cola as only person in the Netherlands, I will be a millionaire in a couple of weeks. That's quite clear. And that's not because I'm a huge entrepreneur, therefore it couldn't be taxable with me. And the point here is that the Netherlands is being perceived by the main EU states still as a tax haven. And to my opinion, this has all to do with other reasons. That is all to do with financing COVID or whatever. But every country knows that our implementation of the 8.1, 8.2, other directives has been stronger than by other states in the European Union. And exactly this example, onshoring is a specific situation which does not cost any other state money in principle, because Bermuda is allowed to tax their 0% on the sale of the IP to the Netherlands. So there's no difficulty there. The difficulty, of course, is for the countries which are paying to the Netherlands, but they should have paid anyhow that money. But then still, due to the structure in the Netherlands, it would lead to, on a pan-European, on a global basis, to lead to a lesser tax burden for the sum of the countries. So what are we doing? The source state which has to pay a license fee, they had to pay it anyhow. So in principle, from deduction part of view, there's not a difference here. In the Netherlands, yeah, it's deductible. Suppose that the sale of IP still goes well. The depreciation, of course, is deductible. But on a global basis, there's no state which ends up in a situation where they say, okay, due to the Netherlands, I'm missing so much money. And still that's going to be changed. The discussion from litigation point of view, if you want to challenge it, what actually happens is not that we don't accept the IP, as I said previously, but we just say from 2022 on, you cannot deduct the depreciation anymore. Well, what I'm doing more and more last couple of years actually is in this situation, a tax treaty doesn't really help because it's a change of our tax law. We could say domestically, it's a retroactive effect. Well, we already had a court with the European Court of Human Rights about retroactive effect of Dutch legislation, which has been lost. It is a little bit different. It could possibly work. However, I'm not that convinced about it. And as said, it does take years and you never know the outcome. But here, possibly, a discussion could take place. Yeah, and that's also difficult because 3 states are here in discussion and not 2. Whether the Netherlands would, under a bilateral investment treaty, by actually saying that the depreciation is not deductible anymore, the company is harmed. The company is due much more money than to be expected, since it has a retroactive effect. The point, however, is that the bids, we have many bids in the Netherlands, but I'm not fully sure whether we have them with, for example, Bermuda. We have many well-known offshore countries. We have bids with them, but there is other development going on with these bids, and that's the main issue, and it will be discussed also next week. The European Court of Justice decided in a Dutch insurance company case on bids, and as a consequence, the European Commission came up with a plan to harmonize the bids. And under these new bids, taxation is fully excluded. Still, in most bids, there is a provision that even if the bid is cancelled, you can still go after 10 years back to that bid for a specific situation. So in 10 years' time, we could go back to now. And then you go into a arbitrage of situation. Then it's a matter of the IP, and the strongest position would then be whenever you sell the IP from, for example, Bermuda to the Netherlands, because then there's a real transaction in stake here. And then in an arbitration situation, the question could be raised. At the moment of the sale, it was clear that there should have been a depreciation of the IP right. And at a certain stage, the Netherlands changed the law, and therefore, it infringes the rights, the protective rights of, just let me call it, the company. It's difficult. From a political perspective, there is still one very interesting possibility, as I mentioned, and that is that whenever you sell the IP, you have a capital contribution in the Netherlands, and you could use for the dividend withholding tax issues, because if the parent is in an offshore structure, or a private equity firm or whatever, then it's difficult to apply our dividend withholding tax exemption. A capital contribution leads to a high capital, and that leads to the possibility of paying back that capital. There are certain conditions to be fulfilled. I'm still worried in that situation about our Vrouws Legis doctrine, because I can imagine that also in this situation, the Dutch government is not going to accept and is going to actually to see the repayment of capital as a form of a dividend distribution. In a litigation, we already have case law about a specific topic. If you fulfill the corporate law conditions for the capital repayment, I foresee that we have a strong position here to challenge that one. So it's the most difficult one if, as said, politically speaking, we are now in a cabinet, a government which is not really active. We're still working on the new government, and it will take months. And they're not going to use these subjects as too important to shift into the future. So these are shifting to the future. So it could mean that the date of entry will be 1st of January 2023, but it could also mean that the only form of capital contribution of onshoring, namely the sale, which is not yet being planned, that still possibilities 24, 25, if they're going to plan it. And if they don't plan it, it's going to work quite well. But that's a little bit about the current discussion in the Netherlands.
Great, thank you. I think this is very important, very interesting to note. I think it's interesting to see under German constitutional principles, we do have a very strong distinction between retroactive effects and retrospective effects. And here we would say, well, we only disregard the future depreciation and not the past one, which gives our government much more of a potential to apply rules in such manner. I would still hesitate to say that this is possible here because the financial disposition has been done already on the basis of having an aggregated system. And
I see that. Yeah.
if I get you right, and then that's one thing I'm probably struggling with most, is you would still have to depreciate the IP, so you lose your tax basis. If you then offshore it or reshore it to another jurisdiction a couple of years later, you've depreciated it, non-deductible, and would still capture the full gain for tax purposes?
That would be another issue to discuss because we don't know that yet. Suppose that you would have it onshore and you would relocate it to a third country. You did depreciate it from other purposes. But then possibly I would say, based on a case law from the 90s, that if the tax depreciation is not allowed, that the original price or the price from the moment that you couldn't depreciate anymore is the basis for the exit tax. And by the way, Gunnar, we are in the Netherlands, and I'm always very much ashamed to say so, the only state with one island somewhere in the Caribbean where you cannot test a law to the Constitution, as you know, as you probably know, and therefore the government can do what they want. About the retroactive effect, one case is brought to the European Court of Human Rights, and that's the case that today it's announced that there is no possibility for depreciation of IP, for example. So suppose you would have that, and that law comes into force in 3 years' time. Then we still say today is the day when we start, and then discussions have taken place that this is materially speaking retroactively because the law comes into force in 3 years' time. It works back to now. But since it has been decided that from now on this will happen, that period is not really retroactive effect and is acceptable. But if you say, I already onshored, and then we are going to limit your depreciation, that seems to be a little bit different situation. Just to inform you that in a couple of weeks' time, I'm invited with 2 senators and 2 people from the Dutch parliament to discuss this issue with them. Because, happily, there are some people worried about the effect because, let us be honest, these kind of proposals do not make the Netherlands a very interesting country to invest, because one thing multinationals want is a stable political system where they are not going to be confronted with all kinds of unexpected changes, which actually lead to nothing, at least not for the companies. So that appointment stands in a couple of weeks, and hopefully that some of our politicians become a little bit more clear what we're actually doing.
Very interesting. Thank you. Do you have any comments on this, Phillipe, as a final addition?
Not a huge amount. I mean, just on the retroactivity and retrospectivity. I mean, what you just mentioned, Hans, is quite interesting. I think it's effectively what we already had in the UK in a different context with the FII group litigation, where we had a number of attempts by the UK government to introduce retrospective legislation. And there were 2 bouts of that. One was in the Finance Act 2004, where effectively the Paymaster General stood up in Parliament and said, you know what, we are going to ban you from doing this. and the law passed into effect some months later when the finance bill came up, and it went back to the date of the announcement. And that was